Professor Daskal's paper is really, in the privacy realm, something that is very timely and practical, which isn't always the case with the papers that we might have the pleasure of reading in any academic realm, including privacy. But her paper on law enforcement access to cross-border data is a very real, a very hot issue, one that concerns Congress. There's legislation that was pending in the last Congress on international communications privacy protection, and her paper suggests reforms and changes to the Stored Communications Act and the Wiretap Act. The executive branch has been litigating a case against Microsoft that we may have a chance to talk about and is discussed in her paper, and has decided to make an issue of compelling the production of customer data from servers located in Ireland. Of course, the case is pending before the courts in that case and in other cases. And of course, companies that either provide global cloud platforms or use them have data that is potentially accessible to law enforcement. So this is a paper with important both observations, analytic observations, but then offers a way forward and a potential solution. In a nutshell, I guess I would say that my takeaway is that there should be harmonization for international law enforcement access to data with a US flavor. Have I got that sort of right, Jen?
A little.
So how would you describe what the needs and the risks and needs for your paper? You describe this as being a situation where doing nothing is not a preferred policy option for the United States.
Sure. So just stepping back a little bit, I mean, I think the key problem here is that we're dealing with data which is inherently unterritorial, and states' attempts to regulate data in an inherently territorial manner. And this is causing, at least within the United States and for foreign governments, two key problems. One is the question of how far U.S. law enforcement authority can reach to data that happens to be stored outside the United States. And there's a converse question, a converse problem about the ability of foreign governments to be able to access data that happens to be held in the United States. And the key issue in both cases is the old 1986 statute, the Electronic Communications Privacy Act, which was written before we had the cloud, before we had a global internet, and doesn't deal with either of these questions in a particularly satisfying manner, and in fact doesn't really deal with them at all. And so, as Alan pointed out, there's a case that's now pending for a rehearing en banc that was decided by the Second Circuit, the Microsoft Ireland case, where the Second Circuit basically said U.S. warrant authority is only limited to data for stored communications content that happens to be located in the United States. This has, I think, negative privacy, security, and economic costs, and maybe we can talk about that a little bit more. And then there's a converse problem that this old statute prohibits US-based providers from turning over stored communications to foreign governments. And it prohibits that even if the UK, for example, is investigating a local murder in London, local target, local victim, local perpetrator, and the only US connection to that data is that it happens to be US held. Well, the law now requires that the UK government, instead of going directly to Google or Microsoft or Yahoo, any of the providers who might hold that data, has to make a diplomatic request to the US government through the Mutual Legal Assistance Treaty process. Anyone who's ever worked with this process knows that it's a long, laborious, inefficient process. According to a study a couple of years ago, it takes an average of 10 months to process those requests. My guess is it's taking longer now because the rate of requests is increasing exponentially as more and more of our evidence is digitalized. And so foreign governments are frustrated, and they're responding, in my view, in a number of concerning ways. They're mandating data localization as a means of ensuring access to the data in ways that have all kinds of negative costs. They're asserting unilaterally extraterritorial jurisdiction in a way that creates a direct conflict of laws and puts companies in the middle, having to decide which law to abide by and which law to break. There's been examples of company executives being hauled off to jail. And it also is incentivizing, I fear, governments seeking alternative surreptitious means of accessing data that they want for legitimate law enforcement investigations. And so those are the two problems that I address in the paper.
One of the factors that you point out is that this is a U.S.-centric issue because of the dominance of U.S. providers, ISPs and electronic service providers, remote computing service providers. So why is this not an area where the U.S. ought to decide what's best for us and not worry so much about the rest of the world's access? What are the harms or the risks that you see resulting from that?
So I think there's two separate issues. One is the reach of U.S. law enforcement authority, where I think the answer is to a certain extent focus on U.S. law enforcement needs, but also take into account foreign governments' concerns as well. And then there's a second question of foreign government access. And the U.S. ought to care for the reasons that I just laid out, that unless the United States amends its law to grant, to facilitate access to this kind of data in certain circumstances, I think we run the risk of encouraging data localization, which is bad for privacy. Most foreign governments can access the data according to standards that are much less privacy protective than the United States. It's bad for economic growth. It potentially prices small startups out of the market. Mirroring data, holding data in a number of different countries is expensive. Some of the big companies can handle those costs. Little startup companies can't. They won't be able to compete. And I think it also, as I said just a minute ago, I think it incentivizes foreign governments seeking access to the data through surreptitious means, which is bad for both privacy and security.
So you have in your article a very thoughtful suggestion on kind of a reform approach that would harmonize the access to data in a reasonable and proportionate manner, subject to certain standards. And I'm going to ask you to describe that in a second. But before we get to the solution, sticking with the problem, do you think that if a solution were adopted that reflected the balancing of different countries' interests and there were comedy or harmonization, would it stop the data localization trend that we're seeing, for example, in China and Russia? Would it see a movement away? One of the other points that your paper addresses is a move towards anti-encryption, I think you put it, and the use by government agencies of malware, what I think might be described as network investigative techniques in the U.S. context. And another point that you mentioned is the coercive threat to employees of, let's say, ISPs in, let's just say, Brazil. Do you really think that a kind of a global comedy-based approach and balancing is going to overturn this trend, this pernicious trend?
So I'll say two things. One is that just to be clear, I don't think that we're anywhere close to having global harmonization on the rules. I think that at best we can engage in some sort of bilateral, multilateral negotiations in ways that facilitate and ease some of these pressures. I don't think that doing that is going to cure the incentives for data localization or use of malware or extraterritorial assertions of jurisdiction. But they can help and they can ease some of the pressures, at least with respect to the states with which the United States is engaged in those discussions and those negotiations. And I think you have to start somewhere, even if it's starting small.
Great. Well, let's talk about the solution. And by the way, there is going to be, even though we've gone from 10 hours to 10 minutes, we'll try to provide a little bit of opportunity for questions. So if somebody has a question they'd like to ask, just kind of signal by raising your hand sort of halfway, and that'll let us know to save more time for questions. So, Jen, if you could just describe the package of reforms and changes that would be necessary to implement the type of solution that you could also describe for us.
Sure. So again, as I've said repeatedly, I think there's two parts to this. One is the question of the scope of U.S. warrant authority abroad. I think the Microsoft Ireland case was a bad decision, and that Congress should correct that. And I think they should correct that by granting the authority of the U.S. government to reach stored communications content from U.S.-based providers, but also require that the court in the analysis takes into account the interests of foreign sovereigns, takes into account comedy concerns, takes into account things like whether or not the foreign government has has in place certain provisions that would require the United States to work through that foreign government's law enforcement processes in order to access that data. So that's point one. The second piece is foreign governments' ability to access data that's located in the United States. In June of last year, the Department of Justice introduced some, I think, interesting draft legislation that would amend the Stored Communications Act to allow the executive to enter into executive agreements with certain countries if those countries met a number of specific requirements, including that they were law-abiding and that respected due process and the rule of law. And pursuant to those agreements, that foreign government would be able to directly request data from US-based providers about non-US citizens and people located outside of the United States. But if those foreign governments wanted to access data about US citizens or persons located in the United States, they would have to work through the Mutual Legal Assistance Treaty process and ultimately obtain a warrant based on probable cause. And I think it's an interesting approach because I think it does a better job of reflecting the normative interests at stake. So as a country, we have an interest in setting the rules for our citizens and our residents, and there's principles of democratic accountability that suggest that's the right answer. Citizens can shape the rules, citizens can vote, citizens can argue about the rules. Our residents, people who come here, choose to be bound by our rules and our procedures. But there's much less of a justification for the United States insisting that foreign governments seeking data about their own citizens in connection with local crime have to abide by our particular procedures. Now, with one important caveat, the legislation also specifies a number of minimum procedural and substantive standards that must apply with respect to these requests. So they have to be targeted, they have to be time limited, they have to be reviewed by an independent judge, there has to be protections against dissemination and retention of irrelevant information. And I think those are also important for a couple of reasons. One, because as the United States, we have a role and I think a responsibility in ensuring promotion of fair process and basic human rights norms. And also because if I'm right, and what really matters to us as a government primarily is protecting the interests of US citizens and US residents, the reality is that data is intermingled, and at times that data is also going to be collected pursuant to these foreign government processes as well.
Is it fair to say that one of the observations in your paper is that to the extent that foreign standards apply to accessing the data of the foreign citizens, even if held by US service providers, that it could be subject to actually less protection and fewer safeguards than if a US regime applied?
Yeah, I think that's exactly right. And to the extent that there's resistance to change, that's the source of the resistance. The concern is that if you amend this law and you allow foreign governments to access data that's held in the United States according to their own standards, it's going to be done pursuant to less privacy protective procedures and substantive standards. Which is why I think that it's so important that the change in the law, to the extent that there is a change in the law sets out the minimum standards that need to apply. They don't have to be US standards. The concept of probable cause is a particularly American standard, and it makes not a lot of sense to impose that standard on countries around the world that don't even really know what that means. But at the same time, it does seem appropriate and correct that the United States should say if you're going to access data that's within our borders, you have to at least meet minimum standards, even if you do so through your own processes.
You mentioned that the decision out of the Second Circuit, the Microsoft case, which involved a challenge to a search warrant for the communications of Microsoft customers stored on servers in Ireland. And the court held that the Stored Communications Act did not authorize an extraterritorial search warrant and therefore denied the U.S. government, in this case I believe it was the Drug Enforcement Agency that was working with the Justice Department in the Southern District of New York, access to this Irish located data. You say that was a bad decision. Is it a bad decision because of the outcome, which is to say holding that the Stored Communications Act doesn't apply extraterritorially? Or was it a bad decision because it was based exclusively on the location of the servers and the server in Ireland and no other factors?
So I think it's both. Sorry. I think it's a combination of both. So in analyzing the statute, the Second Circuit, all parties in the case agreed that the statute, the Electronic Privacy Communications Act, does not have extraterritorial reach. So then the question in the case was this a territorial search because Microsoft could access the data from Reading, Washington, from within the United States, or was it an extraterritorial search because of where the data was located? And in adjudicating that dispute, the Second Circuit basically decided that the focus of the statute was on privacy. The privacy intrusion occurred where the data was seized, which was in Ireland, and that therefore this was an extraterritorial search. And since everyone agreed that the statute does not have extraterritorial reach, this kind of search was impermissible. I think that doesn't make sense for a couple of reasons. One, as I've already said, if we required the United States to go through other governments' processes to access data, those are generally going to be less privacy protective than the US standards, so it actually potentially undercuts privacy. But also, if you think about it, in this case, Microsoft controls access to the data. Microsoft moves around this data all the time without notifying customers, so without notifying the users. And so to the extent that there is a privacy intrusion, if the focus of the statute's on privacy, that intrusion occurs when that data is transferred from Microsoft to the government. And that happens in the United States, not in Ireland.
Thanks. I think we're just about out of time. At least the signal had indicated that. Is there any question from the audience? There's a question here, maybe two questions. Yes.
Sure. The question is, what do I think about the EU-US umbrella agreement, and will this solve any of the problems? So the EU-US umbrella agreement is interesting, and I think there's a lot of these discussions are also now happening in Europe on a whole range of issues. The EU-US umbrella agreement doesn't address this question of law enforcement access to data, so it addresses a different set of problems and a different set of concerns. So it won't resolve the specific issues that I'm talking about here.
Last question.
So I think that's right. So the question is, the question was, and which is a true statement, that in the Microsoft Ireland case, the court focused on the fact that this was a warrant as opposed to a subpoena. And the question was, if this was a subpoena, would the results have been different? I think, well, two things. One, under the Sixth Circuit decision in Warshak, in order to access stored communications, you need a warrant. That's what the Sixth Circuit said, and the government's applying that across the country, not just in the Sixth Circuit. So we're talking about stored communications content, so they had to get a warrant. If we were talking about the kind of data that could have been obtained by subpoena, I think you're right. The results might have been very different because there is longstanding case law that basically says companies are obliged to turn over property data that's within their custody or control, regardless of where it's located, pursuant to a subpoena. So I think you're right.
So I just need to interject on that one point, and on that I think I need to make the disclosure that I filed a brief for AT&T in that case. And one of the arguments that we made and that tried to bring before the case, because there was this tension, is this really a hybrid process where it's called a search warrant, but it's really like a subpoena? But the case law that goes to providing access to records within the custody control of a company pursuant to subpoena is where it's business records of the company itself. So that's the Bank of Nova Scotia and the Mark Rich case, Mark Rich in the Second Circuit. Under the Stored Communications Act, the content of these emails that were stored by Microsoft in Ireland were not its own business records. And that was an important distinction. They were the content of customer communications. Microsoft did turn over to the government its own business records in that case, which was the metadata. So the metadata, which it took the position was its own transactional history, its own business records, was provided to the government, not the content of the customer communications. And the idea was that would distinguish it from the case law on subpoena access. So I think with that, we really do need to end. Please join me in thanking Professor Daskal for a great paper.